of that court and the initial appearance, the president of the country downed the tools of power openly and publicly and signed a deed, in which deed he appointed his deputy for approximately 60 hours or thereabout to act as president of the country so that he could attend to what he termed a private and personal matter as a private citizen, Mr. Uhuru Muigai Kenyatta. My lords and my ladies, on the second argument on that point, we submit the President of the Republic of Kenya has no right to initiate a popular initiative. Why? Because this avenue of popular initiative is reserved for private citizens, including civil society, and is not available to state officers or state organs. The learned judges in the Superior Court was the history, the checkered history of Kenya with constitutional amendments. And therefore, it was clear that citizens wanted an avenue where they can amend the constitution and force government to legislate things that they think government through the organs of state does not wish or is not ready to legislate. How then can the same government, which is supposed to be compelled to legislate by the people through a popular initiative, be the same government using that avenue? And therefore, we agree with the learned judges of the Superior Court that there were other avenues available to the head of state and the president to initiate whatever amendments he wanted to do. First, under Article 132 of the Constitution, the cabinet may make proposals to, for legislative proposals. The cabinet can do that. Also, the Attorney General under Article 156 of the Constitution normally aids the President in bringing government legislation. And under this Constitution, particularly, the office of the Leader of Majority in the National Assembly and the Leader of Majority in the Senate is actually the avenue through which government bills and legislation proposals are channeled. And I speak that with some little authority by virtue of my previous background outside the premises of what we are dealing with today. That therefore this was the wrong avenue for the president to use, and he had other avenues to use. Secondly, on the same point, the second reason why we say that this route is not available to the President of the Republic of Kenya is because, as it was found in the Superior Court, that there was no evidence tabled to provide that the president had used other avenues available to him and failed. On the second thematic area of public participation, which my learned colleague Gerono has submitted, I just want to add the following comments. First, I was somewhat surprised when learned senior counsel Tiende Amolo yesterday, or is it the day before, submitted before this court, tried to demonstrate how it is it's impossible for all the steps of public participation identified by the learned judges in the Superior Court for public participation if we are to allow Wanjiku to be the one to drive the popular initiative. We disagree with that view because, and I heard senior counsel Tiende Amolo exemplify and ask the courts to reflect on whether, for example, Wanjiku can have the bill published, I don't know, in the national languages, the national language, which is Kiswahili, the official languages, which is English and Kiswahili, the vernacular or indigenous languages, and so forth and so on. And he said if we submit Wanjiko to this kind of procedures, it will not have been possible, and I hope I'm not misquoting Learned Senior Counsel. Our view is that this demand, this 10-step process demand, was not the invention of the learned judges in the Superior Court. It is a dictate, a requirement of the Constitution in Article 7 of the Constitution, which the learned judges relied on, which calls on state organs and state processes to, for example, use the languages and even try to promote indigenous languages and the use even of Kenya Sign Language and Braille where possible. And when it comes to the technical side around Braille and Kenya Sign Language, the Constitution is considerate and uses such terms as be done. And therefore, on participation, it is a demand of the Constitution. Secondly, on the same theme, it is our submission that both the popular initiative and the parliamentary initiative must therefore adhere to what the learned judges provided for the 10 steps of public participation. There was very little public participation in the processes that were taken up to this point before this litigation arose. For example, the example was given of Siaya, which passed the bill upon receipt. Siaya, in their wisdom, the assembly in Siaya County, in their wisdom, decided to pass this bill within 24 hours. I don't know whether they did the public participation at midnight or at 3 a.m. and what methods they applied. Within a day or two, they had passed it. Tana River attempted to do the same, but the county assembly of Tana River was stopped on their tracks, and their action, which had already taken place, was nullified by Chepunyi J, sitting in Garsen, where he said that you cannot submit a bill, a process of enacting such a fundamental bill amending the Constitution and process it in microwave time. In fact, that is the term. You'll see that when you retire in the authority which my learned colleague Gerono cited. It's called Abe, like Abe Shinzo, Abe Brere. Abe Brere, I hope I'm not mispronouncing, Abe Brere versus the Speaker of the County Assembly of Tana River and 2 others. And the judge said, don't even take what you have passed to Senate or even National Assembly. And the thing died. But because the promoters had already had their kill, they had enough majority, so they proceeded, notwithstanding that they didn't have Tana River County Assembly on board. And my Lord, why are we emphasizing this? It's because there is a reason why the Constitution demands that the bill be submitted in Article 257, the bill be submitted to the county assemblies for 90 days. The county assemblies have 90 days to process the bill. There's a reason, and that reason is participation. I say so because I had also the submissions yesterday by learned counsel, Mr. Gumbo, who told this court that in a different issue of signature verification, the regulations demanded that IBC should take 14 days. But in the wisdom of IBC, they decided to shorten that process to 5 days, which included a Sunday, which is normally not computed in terms of time. And therefore making the whole issue of statutory timelines a laughing stock. I am afraid to submit that, unfortunately, for such an important institution of the state like IBC to be dragged into this business of hop, step, and jump, similar to the legend in the Simon Makonde story, where in 7 days, the politicians involved in this process actually marshaled and stampeded millions of signatures in 7 days, like Simon Makonde, who was born on Monday and something happened on Tuesday. I think he wasn't named. He got married on Wednesday. On Thursday, I think he fell ill and water.
I'm not sure it was the same week, but carry on.
Thank you, my Lord. My Lords, therefore, we submit that public participation must start earlier and continue throughout the process, and it must involve the people. We also submit that the appellant's erroneous view that those who signed to support this bill, the 1 million that signed, are presumed to have understood the content of the bill, which is the gravamen of the appeal, part of the gravamen of the appeal by the Honorable Attorney General. This submission cannot stand because, my lords and my ladies, that public participation cannot be presumed. The authorities that we have filed, the Robert Gakuro versus County Government of Kiambu, the Doctors of Life case, and so many other cases, even outside this country, we filed them in our documents. These authorities say that public participation is both qualitative and quantitative. It cannot even be presumed, it has to be real. I think in Doctors of Life, the judges said it has to be real, not illusionary or thereabouts. Therefore, when you see county assemblies, almost all of them, the entire country, passing such a monumental, or rather passing or endorsing such a monumental bill, which is amending not less than 74 parts of our Constitution in a swap, making the regime of...
Counsel, sorry. Was that part of the evidence before the Superior Court? The statement you make? Is that
which one in particular?
That the county assemblies passed it in speed light. Was it a matter of evidence before the Superior Court?
You know, my Lord, I don't want to lie to the court. I came on board this matter at this level, and therefore I don't want to take responsibility for that, and I'm relying on our written submissions. So maybe that's something that Mr. Mutuma can clarify. Okay. Thank you. Ms.
Counsel, Prof, just a point was raised about who bears the burden. They seem to say that consistent with the requirements of the Evidence Act, he that alleges must prove, and they said that insofar as your clients were alleging that there was no public participation, it fell upon you to prove that. What's your comment on that?
I absolutely agree. That is the position of the law. But in context of this matter, once, first of all, there is the standard of proof, which in this kind of a matter, which are not entirely civil matters, they are sui generis proceedings, but they are not criminal matters. So the standard is normally of a lesser, it's on a balance of probabilities. And I think at the Superior Court level, the issue of public participation, lack of it, was proved to that level, and that's why the judges took a bit of time to agree largely with the appellants, with the petitioners' positions and evidence. I am referred by Mr. Mutuma to page 1663 of our volume 4 of the Record of Appeal. Volume 4 of the Record of Appeal, page 1663, where the issue asked by my Lord, Mr. Justice Tuyot, is answered in the affirmative, particularly the affidavit of Miruru Waweru, paragraph 8. how the county assemblies passed this bill, considered this bill in a lot of haste. Because of my time, my lords and my ladies, we also note that the MCAs, which is a fact, were given a car grant, but that's neither here nor there. That does not mean that they didn't have to follow the Constitution and the timelines given by the Constitution. Our submission is that the timelines given by the Constitution or statute are deliberate. They cannot be played about with or hurry them up, especially when they concern such serious and grave amendments.
The period was reduced from 90 days to how many?
Within 30 days, I think the entire country, except one or two, like in Meru took a little more time, maybe about 40, 45 days, I'm not sure. But the rest of the county assemblies consider this bill in less than 30 days, within 30 days. And that is in our affidavit.
In your view, what was supposed to happen after it's committed to the county assemblies within that 90 days?
Qualitative and quantitative public participation.
Through the county?
In the county, by the county assembly, which of course includes, if you look at it from quantitative and qualitative approaches, that includes time. And for me, they should have taken most of the 90 days to comply with the 90-day deadline, maybe 60 days, 70, 75, 80, or even 90 days. My lords, my ladies, allow me to rush to something which was submitted here by Learned Counsel, Senior Counsel Atiende Amolo, on the JLAC report of Parliament, because he made some remarks that it's not binding. I just want to say that this report is a public document. We also have produced it as a result of the directives of this court to adduce additional evidence. We want to simply submit that this report of the Joint Committee of the National Assembly and Senate, the Committee on Legal Justice and Legal Affairs, this report was tabled in the two houses of Parliament, and once tabled, it became the property of the two houses. And it is not true to argue that once it was tabled, because it was not voted on, then it has no evidentiary value. We believe and we submit that both that report and the within the proceedings in Parliament, including the Justice and Legal Committees of both houses, it was clear the finding of the report was that many provisions in the bill, the proposed amendment bill, were unconstitutional. But surprisingly went ahead and said, but we recommend it be enacted. For example, the issue of Schedule 2 to the report, the JLAC report, which consisted the list of, the issue of additional constituencies. The committee found that there were legal issues that made that schedule inconsistent with the law, and recommended actually, there was a recommendation even of severing that Schedule 2 from the report. But we want to leave it at that and say that it is not true that these proceedings and these reports are of no probative value. We submit, my lord and my ladies, that I also listened with significant surprise also as Learned Counsel, my senior Mohamed Nyauga, told this court something about the immunity of the head of state. And I thought I should just, in a snippet, submit that, the old idea of absolute immunity of heads of state has been abandoned in all the constitutions of the world and under international law. It's an archaic legal doctrine, originally from international law, but which got infused in national constitutions. But since, especially 1990, the landmark international case of, which this is not in our submission, but just we have the court, the Pinochet case. The Augusto Pinochet was a former head of state in Chile, and he did what he did for many years and fled and went to Europe. He was arrested, extradited, returned back to Chile. Judges made it very clear, the House of Lords, that it is not the job description of a president to torture and kill people. So immunity cannot be absolute, because those were their charges against Pinochet. And from there, that doctrine is old, and the court should not give any effect to an argument that immunity of the president is immune. The Constitution in itself, the court really guided on that area, is very clear. Does not include commission of international crimes, does not include when the person leaves office, it does not include actions which are not functional. They are not related to the function of the head of state. My lords, my ladies, allow me to say a few things. I know I have 12 minutes on the basic structure. And I'm sorry, my Lord Justice Kiage, I have to do this because the same thing can be attacked from a million sides, and I won't repeat. I hope I won't repeat anything about basic structure. And for me, what arises from all this discussion about basic structure, eternity clauses, and so forth and so on, is whether, my lords and my ladies, there is a hierarchy of norms in our Constitution. That is the question. Is there a hierarchy of norms? We submit that there is a hierarchy of norms. Why? We can even start with Article 255 itself. 255 is saying, my lords and my ladies, 255(1) is saying you can amend the Constitution through Parliament under 256 or through the people under 256. But there are 10 or so things you cannot, whichever method you are using, you must go back to the people. Paragraph A to J of Article 255(1). That's already a hierarchy. It means you can touch the rest, but you can't touch this one. Second example, in the interest of time. Learned Senior Counsel Professor Githu Muigai, who I consider to be my complete hero on this topic of constitutional amendments by virtue of his PhD thesis, submitted before this court yesterday that the Independence Constitution had some entrenched, some superior values, but they were removed. But they were returned again at Bomas, and they found their way in the 2010 Constitution. So what counsel, the Appellant's Counsel have been telling us is that, the court never said what are these entrenched provisions or basic structure or eternity clauses. And without going into the tautology and phraseology, there is, in my humble view, there is a hierarchy of norms. I'll give you an example, my lords, and some of these questions were even raised from the court, to my great pleasure and satisfaction. If you want to change the Constitution of Kenya and remove the provision that says that Kenya is a democracy, I think it's in Article 4.2 or thereabout. Kenya is a democratic state, multi-party democracy. You want to replace that and say, for argument's sake, that Kenya is a constitutional monarchy. Is that really the same as if you want to change the Constitution, Article paragraph 249 on independent commissions, which says that the number of commissioners is between 3 and 11 and 9. Suppose you want to say you lift from 3 to 5 and lift the other side, the ceiling side, from 9 to 11. Will amending that amendment be the same as an amendment that is trying to convert Kenya from a democracy, a multi-party democracy, to a constitutional monarchy? Are they the same? They are not, in our humble view. Second example, if you want to change the territory of Kenya in Article 5 of the Constitution, the territory of Kenya is defined. What the territory of Kenya, what constitutes the territory of Kenya? It is that territory in place on effective date of the Constitution and then split in terms of the whole and the subnational units, the counties. Part of their land, of their space, to a neighboring friendly country. That is how Alaska came to be part of United States of America. If you look at the geography of North America, Alaska is somewhere between Canada and United States. Somewhere in between there. Sorry, the other way around. Alaska is beyond Canada. It's after Canada. So you have United States of America, you have Canada, and then you have Alaska. Why? Because it was, it was a gift. It was sold to the American president, leader, by the leader of USSR. It was part of USSR across the ocean. So it was sold for $3 million, some 300 or 200 years ago. And so forth and so on. Therefore, we submit with great respect that there is a hierarchy of norms. All norms are not equal. But we secondly submit that the judges of the Superior Court did not say you cannot touch these superior, entrenched, basic foundational provisions. They didn't say so. Instead, they said you can change, but not this way, not in the ordinary way. You must go back to the people and the people themselves. That brings me to my last submission, because I have 5 minutes, which I will spend now, on my last submission on this area, which was introduced, again to my great satisfaction and interest, because of my scholarly background, by learned senior counsel James Orengo, on the place of the supremacy of the people, because it's relevant to this. We submit as follows, and I agree with senior counsel James Orengo on this. Elsewhere we've argued this issue, and we are concurrent about the supremacy and the elevated status of an organ which is not really, if you look at it, it's a constitutional organ called the people. With respect to my learned senior counsel Orengo, is characterization that this organ, in quote, called the people, must exercise their sovereignty within the Constitution. For the following reason, my lords and my ladies, if you look at the preamble of the Constitution, the people are the creator of the Constitution. So the Constitution cannot be superior to the creator. It's a creature of the people. Look at the preamble. I know there is a provision in one of the foundational principles, one of the basic structure principles, I think 2 or 3 there, which says, Article 2 or 3 of the Constitution talks about that the supremacy of the Constitution. It's Article 2. It's Article 2. Yeah? Supremacy of the Constitution, how this Constitution is supreme. But that supremacy ends where the power of the people starts. And that's why the Constitution in the preamble is saying, we the people. Let me just read that, I have 3 minutes. Very important.
Professor, as you do that,
Yes.
I understood Senior Counsel Orengo to say that whereas indeed the people are sovereign, the Constitution in express terms says that they shall exercise their sovereignty only in accordance with the Constitution. Those are plain words, black and white.
Which I disagree with, my lord, with great respect.
No, sorry. Are you disagreeing with the words that's how they are written, or you're agreeing with the statement?
I am disagreeing with the notion that the people are bound by their creature. The creator is bound by the product of their creation to do certain things in a certain way.
But can we first of all agree, does the Constitution say that they can only exercise their sovereignty in accordance with the Constitution? So we agree, first of all, we move from text to whether now we agree with the text.
I agree, my lord.
All right, carry on.
Thank you. The reason I argue this is because, unlike my learned senior, James Orengo, who argued that the Constitution is supreme and even the people therefore must act within it, for the reason I have given, that the people are the creator and the Constitution is the creature, the people can even decide to abolish the entire structure here themselves. The people can decide that. And therefore my argument is, yes, the Constitution is supreme, especially the elevated clauses. The Constitution is supreme. But above the Constitution is the people. And I dare say, I dare submit, above the people is only Almighty God and the blue sky. If you look at the preamble to the Constitution, it says, and I quote as I end my submission, "We, the people of Kenya," the opening words. That should even send if you're interpreting the Constitution, that should tell you the first sentence, the first phrase in this Constitution, "We the people," the Creator. We the people of Kenya, acknowledging the supremacy of the Almighty God. The only supremacy above the people is that of God Almighty. It's in our Constitution. I am not bringing theology here. It's in the Constitution made by the people of Kenya. Therefore, without wasting time, my lords, I believe that above the Constitution is the people. And above the people is only the Almighty God and perhaps the blue sky, because it's also hovering over us as the people. For those reasons, therefore, my lords and my ladies, with tremendous respect, I urge this court to dismiss all the consolidated appeals, the appeals as consolidated in their entirety with cost to the respondents. I also urge this court to find that apparently what we are talking about here was a botched attempt to overthrow the people and their constitution at the same time. Luckily, by the grace of the Almighty, the judiciary, through the Superior Court, came and, in my view, rightfully interpreted this Constitution and declared that botched attempt to overthrow the people and their Constitution a nullity. Unless there are questions from the bench, I will request my Lord and my ladies that I be permitted by the court to resume my seat.
I guess there is none. Thank you very much, Professor Kindiki. Can we have the next respondent?
May it please your lordships and ladyship, My name is Gilbert Nyamweya, instructed by Mr. Murara Omoke to lead his team. Your Lordship,
Just say for which respondent?
for the 76th respondent. Your Lordships and Lordships, we come on our knees, pleading that if you could enlarge our time, because our petition is the one that raised most of the issues, and every appellant has attacked the findings of the Superior Court that were founded on our petition. Additionally, we filed a cross appeal, so we will actually need time to ventilate our cross petition. We will not be unreasonable.
No, beyond,
We just
no,
ask-
beyond what time? What you're saying to enlarge beyond what?
45 minutes over and above 1 hour.
I don't know. We'll find it difficult, but just deal with the issues as they.
Yes, your Lordship and Lordships, let me quickly set out the documents that we filed in opposition to the appeal. We filed grounds of affirmation dated 4th June 2020. We filed a notice of cross appeal dated 4th June 2020. My colleague is informing me that our time has been set wrongly. We are on 30 minutes instead of
I did not
perhaps-
know that. Okay.
Okay.
Now, you set it at 40. Set it at 40. For good reason, Mr. Nyamoya, that yes, you may have raised most of the issues, but they have been covered substantively.
Your Lordship, the challenge is that the perspectives that we have towards the issues is a little different from our colleagues.
Can you try to work within that? We will see how far you'll have gone. Please try to work with that.
Number 3, we filed written submissions. I believe that you have our latest copy that is more clear. The assistants were informed. Number 4, we filed a list and bundle of authorities dated 23rd June 2020.
They have been given to us, so please
Yes.
commence. We have them here as a bundle, so please
And
carry on.
we also filed a digest of authorities, supplementary record, and an affidavit.
Put on the time.
I will commence. I will deal with public participation and IEBC quorum. My colleague, Dr. Thiangolu, will deal with the political question and the basic structure. Mr. Murara Omoke will deal with mal-choice referenda, registration of voters, presidential immunity, and he will also tackle the cross appeal. Mr. Topua and Mr. Christian Andole will deal with the popular initiative. Your Lordships, we submit that none of the appellants have made a case to overturn the High Court decision. None of their grounds of appeal can be upheld. I would also like to point out that there are some aspects of the judgment that the appellants have not appealed against. Those we have set out in paragraph 6 of our submissions. Then there is also an attempt by the appellants to ameliorate their appeals, their cases, by changing their positions in the High Court and advancing new arguments. Those we have set out in paragraph 10 of our submissions. On public participation, I will not rehash what has been said. I only emphasize on the guidelines that were given by the Supreme Court in the case of British America Tobacco versus the Cabinet Secretary for Health. The guidelines are quite a number, but I'll only deal with about 3. The first one is that public participation, being the touchstone of governance, must be real. It should not be illusory. And applying it to the bill that was the subject of challenge, we submit that you cannot tell people that being their representatives, elected leaders, that you can just present a document to them and require of them to append their consent through signatures, and you have not demonstrated to them what the document is all about. You must give them an opportunity to know what is in the document, and you cannot tell them that, oh no, you just endorse, you will have an opportunity to participate at the referendum. That is not meaningful. Second, you have to be clear on the subject matter. You cannot have a bill which you tell people that, you know, this is my proposal, support it, and they do not know what is in the bill. You have to let them know what the contents are, and this is to be done through civic education. Again, if you have not published the bill in the languages required under Article 7 of the Constitution, how will they even know the contents? So they will not be clear on the subject of the bill. They will not be clear on what they are endorsing. The Supreme Court also said that civic education is mandatory. The only thing that would matter or would differ is the extent because of the importance of the subject. Now, coming to the importance of the subject, amendment of the Constitution is extremely important. It affects all the facets of life for everyone. You cannot compare it with a sector. If I may use the example of pyrethrum, if you want to develop regulations concerning pyrethrum production, perhaps you will consult a handful of growers, processors, and exporters, whom we know are not so many of them. But when it comes to the Constitution, you must involve everyone. You must ensure that you reach everyone, you give them an opportunity that is reasonable to participate in that process. And that means every Kenyan, whether they are articulate, inarticulate, educated or not educated, whether they are affluent or impoverished, they have to be involved. I would also like to make reference to the submission that was made by the Honorable Attorney General that the bulk of the Kenyan population is illiterate, and it would be nearly impossible to involve them so that they may have a say. We ask you to disregard that submission, because that submission is actually very surprising and disrespectful of our people. When it comes to the question of what are these issues that you are taking to the people to endorse, we submit that you need to separate the issues at the point of signature collection, so that the supporters are endorsing individual issues. You should not give them a corpus of issues and ask them to endorse. They might be disagreeable to some of the proposals. And by giving them an omnibus proposal, you will actually be disenfranchising them. The other subject that we want to talk about in connection with public participation is the notion of political settlements. Political settlements?
Settlements, yeah.
Settlements that was alluded to by some of the appellants, saying that the Constitution 2020 is a product of political settlements, and people should always cede ground to leaders to determine for them what is good for them. We ask you to disregard that notion and actually discard it. Do not allow it today, do not allow it tomorrow, and even ever to prevail, because it will be very dangerous to our democracy. Quickly, I move to the question of the quorum of IEBC. I'll also not reiterate what has been said by other respondents, save to say that, though regrettable, that IEBC does not have a complete composition and it's not quoted. IEBC itself should not be apologetic about it. It should not be defensive about it. IEBC does not constitute itself. It is only a victim of circumstances. These vacancies rose not 1 year ago, not 2 years ago, not 3 years ago, but 4 solid years. So why haven't they been filled? I believe that is the kind of dream or novel or movie that Senator Orengo was referring to. This is the one in this whole conundrum. And none of the appellants asked that question. Why are we at this place where we do not have a quorum IEBC?
Yes.
We would also like to point out that IEBC, having been left to be in limbo for 4 years, that's a very dangerous position. The country is actually standing on the cliff. Additionally, these 3 commissioners who are in office, even if they may try hard as they may to discharge some of the functions of the commission, are they representative of the face of Kenya? Because we believe and submit that the reason why IEBC was given wide membership is so as to have inclusivity of our people throughout the Republic.
Yes.
As I wind up my part, I would like to leave you with this quotation that was written by Abraham Lincoln. He said, "Stand with anybody when he is right, and part with him when he is wrong." In this particular case, we ask you to stand with the people, because this time round, the people are right, and they do not want their right, inalienable right, to be snatched from them. At this point in time, I invite my colleague, Dr. Tiangodu, to continue from.
Thank you, Mr. Weaver. Sorry?
I want to project.
Sorry?
I requested the court assistant to project something I want to show them. The DStv run and the setup. Oh, it's on our screen, my lord.
Where did it come from?
It's part of my presentation, my lord. They started my clock, my lord, before I even introduced myself.
All right. Okay.
My lord, I've been constrained to fundamentally alter my presentation in view of...
Just introduce yourself first for the sake of the record.
For the record, my lord, my name is Mudomi Nkolu, representing...
Is it Dr. or Mudomi Nkolu?
The actual name, my lord, is Mudomi Nkolu.
Okay.
It is an element of vanity to say I'm Dr. So-and-so or Professor so-and-so.
I heard that reference earlier. That's why I wanted to confirm.
Yes, my lord.
Okay.
Now, my lord, I only mentioned two things in my presentation. One is what I believe should be the overarching questions